And he wrote back, and this is Philip Ruddock, and it's actually signed by Philip Ruddock, which is pretty unusual. And at the end he said this: "You may, however, be interested in some observations of the current Chief Justice of Australia, the Honourable Murray Gleeson, AC, in a recent publication, The Rule of Law and the Constitution, ABC Books 2000. The Chief Justice states at page 6, the sovereignty of our nation lies with the people, both as a matter of legal principle and as a matter of practical reality." So that's the Chief Justice of the High Court. You can't go too much higher than that. And he is saying that we are sovereign as a matter of legal principle and practical reality. However, if you go into a Queensland court, I can't say what the other states are, what their legislation and so on is, but this is what a Queensland police officer swears as his oath: that I will well and truly serve our sovereign lady, Queen Elizabeth II, her heirs and successors according to law. So he's calling her our sovereign lady. The Chief Justice is saying we are sovereign. And wherever you see Queen Elizabeth II, her heirs and successors, that is the Queen of the United Kingdom. Because in both Royal Styles and Titles Acts 53 and 73, there was no act of succession passed for heirs and successors. So the Queen of Australia has no heirs and successors. So that is the Queen of the United Kingdom. However, it gets better. In that same court you will have legal practitioners who swear this oath: I, their name, do sincerely promise and swear that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II as lawful sovereign of Australia, and to her other realms and territories, and to her heirs and successors according to law. So there in that court you will have legal practitioners swearing allegiance to Queen Elizabeth II, her heirs and successors, as lawful sovereign of Australia. So that's fairly amazing that you have solicitors swearing that when the Chief Justice of the High Court says we are sovereign. The magistrates' regulation is the same: Queen Elizabeth II, her heirs and successors. And even under our Queensland Constitution 2001, the politicians swear the same. I, their name, do sincerely promise and swear that I will be faithful and bear true allegiance to, and Her Majesty's name has to be put in there, as lawful sovereign of Australia, and to her heirs and successors according to law. So there you have the politicians in Queensland, I can't say what other states do, swearing allegiance to the Queen of the United Kingdom as lawful sovereign of Australia. And it seems to me that if England indeed is a foreign power, as the High Court states, all these people swearing allegiance to that foreign power could possibly be charged with treason. Now I wrote again to the Governor-General, Major Philip Michael Jeffrey, and I wrote to him regarding clause 68 of the Constitution, which says, the Command-in-Chief of the Naval and Military Forces of the Commonwealth is vested in the Governor-General as the Queen's representative. So that's a crystal clear statement. He is the Command-in-Chief of the Naval and Military Forces. And of course that was put in there for a good reason. That was your separation of powers, so that you didn't have a dictator in control of the Army, the High Court and so on. And I got a reply back when I asked him to forward me the documents that he issued to John Howard authorising him to send our troops overseas. And the answer was, the Governor-General appreciates the time and trouble you have taken writing to him about your concerns. However, the title of Commander-in-Chief held by the Governor-General under Section 68 of the Constitution is a titular command. This does not entitle him to intervene in the administration of the Australian Defence Force. So there you are. He's they're saying there that John Howard can do what he likes with the Defence Force, and the Governor-General's titular only and cannot intervene. Well, that's certainly not what it says in section 68. That is crystal clear. So as you can see, our separation of powers have gone out the window. And just to further stress that point, there's a very dedicated group of people that took this whole business to the High Court Chancery Division in England about legality in Australia. They went right through to the High Court in Australia and of course did no good, because the High Court wasn't about to rule that the Queen of Australia had no authority to appoint Governor-Generals and so on, because the Governor-General actually swears in the High Court judges. So they weren't about to declare themselves illegal. So there again, the High Court is again supposed to be a separation of powers, but they're selected by politicians, sworn in by a Governor-General appointed by the Queen of Australia. So, as I say, your separation of powers is gone. We just don't have it anymore. However, this case went before Mr. Justice Lightman in the Chancery Division, as I said, of the High Court. And he made a couple of interesting statements, although he was pressured not to, but I won't go into that. And he said, well, the issue raised is an issue of construction of the 1900 Act, which is this Act, a United Kingdom statute. So there you are, he is telling you that this is still United Kingdom law. It is an issue that has no significance or consequence in this country. The connection with the United Kingdom is only historical in the sense that the 1900 Act was passed by the legislature here. On the other hand, the issue has potentially substantial consequences in Australia. Well, you'd have to agree with that. It would have substantial consequences, because the High Court has ruled that this is the law of a foreign power being used in the sovereign independent nation of Australia. And he went on to say, in my judgment, this court has no jurisdiction to determine the issues raised in this action. They are not justiciable here. Well, if England's an independent sovereign power, I'd have to agree with that. We can't have foreign courts making rules for ourselves unless we have such an agreement in place. And I would agree with that. But he also went on to say this: as soon as Australia became independent, the 1900 Act, the Constitution, ceased to have any effect as an exercise of sovereign power of the United Kingdom. So he's telling you that this document no longer has any sovereign power from the United Kingdom. And it is still, as I keep saying, British law. And we've heard where the Queen from the British Foreign Commonwealth Office, the Queen of the United Kingdom, no longer has authority, executive authority. So clearly British law and the British Queen no longer has authority in Australia, and yet it's still being used. I wrote again to the Attorney General's office. This was just prior to the 2007 federal election, and I asked him for 2 documents. And please listen carefully to these, because I believe this is most important. The first document I asked